few updates, really. There's an awful lot going on at the moment, as I'm sure you're all well aware. There's great concern about what's going to happen with regard to fees because of the changes to things like employers' national insurance. We are working to get as much information for you as possible. And the same applies with regard to sponsored recruits. With changes to rules and regulations, we try and keep that as up to date as possible. If you do have questions that you want answered, let Dudley or myself know, and we will see what we can do to get answers. You should all be familiar with the sponsored recruit update that came out on the 19th of December. Again, that's been circulated. If you haven't seen it, it's on the website. If you've got any queries that aren't answered by that and you can't get a response from the Home Office or UKVI, then do contact us and we will pass those on. And we also, if you're in the southeast of London or able to get to Southwark, we have a meeting, a live meeting on February, later in February. We'll send the information out with the Gangmasters and Labour Authority coming, and that's primarily to talk about modern day slavery, which is becoming a target area in social care. Any points from you this morning, Dudley?
Just adding to what you're saying, thank you everyone for joining us. Peter and I speak to many providers, and a lot of them are either, it's January, so I understand of thinking what's going to happen this year, what the government going to be doing for social care, what's going to be happening with CQC, what's going to be happening with local authorities, how are they going to recruit staff, and we're trying to cover as many of the major areas that people have got major concerns around just for the survival of their business. And one of the things and areas, especially for today and thank you for coming for today, is around employment and what's going to happen and what the rights are for you as employees and the effects it could have on your staff. We know there's been a raft of elements or things around conduct for the workers. So it's about trying to have a look and keep up to date. So I'm not going to plug Citation, but I'm sure they're going to do enough for them for themselves. But we're very busy just getting on with trying to care for individuals, and we don't want to get caught out, not just from CQC, not from just the Home Office, but other elements as well. So do your best, and Peter and I, and Lcas as well, another plug, to really try and either go on the website, or we try and keep you updated via WhatsApp groups or various meetings across the year. So try your best to see if you can't come on the time, we will do a recording. So actually watch that. Peter will put that up as well. So other than that, we will keep you posted, because we're just like yourselves are on the roller coaster and there's many things happening. So, but thank you for coming today, and I think it's a start. And over to you, Peter.
Okay, thanks, Dudley. We have, if you like, the whole expertise team from Citation with us today. We've got Rosie, we've got Dominic Cooper, and we've also, I saw lurking somewhere, there's Mick Feather as well. So if you don't find the answers or you want to ask questions, please do. If you'd rather not ask the question in the meeting, put it in the chat. If these guys can't answer it there and then, they'll sort it out later and forward it to us so that we can circulate it. Or again, if there are questions that you don't want to ask directly because you think you might be guilty of something, then send it on to Dudley or myself. We will get an answer without involving your name and address, and we can get that back to you. So I would guess that the sensible thing now is to hand over. Rosie has the slides, and Dominic, over to you, sir.
Wonderful. I am just going to get these shared. I've not been on Zoom for a while, so bear with me.
Yeah, okay. Those are the right slides.
Oh, yeah.
Good start. Yeah.
Excellent. So obviously today we're going to be touching on what we see on screen, so the Employment Rights Bill and recent developments. And as Peter said before, Dominic has lots of information to talk you through, because there's a wealth of changes and things that are coming up, as we all know about. Before Dominic kicks off, I'm just going to introduce Citation for those of you that don't know us. So I'm Rosie. I'm the Partnerships Manager at Citation, looking after the care sector. And here at Citation, we support our clients with employment law, HR, health and safety, and amongst other services, which I will touch on towards the end of the session today. And the care sector makes up quite a large proportion of our client base, and we're here to help our care clients to ensure they're continuously up to date, adhering with current legislation, best practice, which is really key, especially at the moment with the changes which Dominic will be talking about shortly. The Citation brand family. So Citation is part of a large brand family with various companies who provide a number of different services with everything you need to make your business safe and compliant. With a wealth of digital tools, there's expertise and knowledge in areas such as training, cyber security, you can see on screen, ISO certification. We can essentially provide a wealth of support for you and your business. And last but not least, before I pass over to Dominic, we're really proud to partner with many, many fantastic care associations, including, of course, Lcas, and we've worked with Peter and Dudley for many years. You've probably seen us at events or received some of our guides and content by the Lcas team. And don't forget that being part of the Lcas network means that you have access to our free HR and health and safety advice lines. And you also receive a discount when you sign up to our services. So later on, or whilst Dominic is talking, I'll pop the advice line details in the chat where you can get some support and guidance if that's what you need. Perfect. I will pass over to you now, Dominic, if you're ready.
Okay, yes. Yeah, thanks very much, Rosie. Can everyone hear me okay?
Perfect.
Yeah, good. Yeah, because I've got a headset, but yeah, you can hear me. I'll just carry on as is. Yeah, so as it says there, 2024 did see an awful lot of change to employment law. It doesn't always change that much from year to year, contrary to what people think. But I think last year and the next couple of years, it is a big shift. A lot of this is quite significant. There was a lot of kind of small changes, which we'll talk about. There was like a wide range of changes, some of which were quite significant. Probably the biggest period of change in about 30 years. I'd estimate. So I'll be discussing the flexible working changes that mentions there and the Worker Protection Act. I'll come on to them a bit later, so I'll just park them for now. I don't think you in the care sector particularly need to know about the Tipping Act, but just noting that it does exist, but I won't discuss it. But in relation to the other two, there are a range of tweaks to holiday rules about this time last year, start of the year. The most significant of which was the ability to treat holidays as accruing month by month based on the hours worked in that month, or indeed that week, whatever the pay period was, and then pay for them as a rolled up lump sum in each week or month's wages, rather than paying for them as they were taken. And that just applies to what we call irregular hours workers or part-year workers. But I know in the care sector, there may well be not so many part-year workers, but there may well be a lot of irregular hours workers who are 0 hours contract or variable hours, that kind of thing. So that's potentially relevant. The Carers Leave Act, that introduced a new right to take up to a week's unpaid leave for employees who have caring responsibilities for dependents. So I can give more detail on that if you want, but I think that's the summary of it. Yeah, next slide, please, Rosie. Just do my COVID thing. Next slide. Yeah, so the most important change last year, I think pretty comfortably, the new Employment Rights Bill, that very much was trailed in Labour's manifesto. It was then launched in October. It did get into the news, so you may well have heard about this. What you may have heard may not be entirely accurate, as I'll come on to. But yeah, this bill made significant updates to a very wide range of employment rights. So the vast majority of the rest of this presentation is addressing those, but I'll flag up when we've moved on to other topics. And I will cover this off more towards the end, but it's worth noting that very little of this bill will come into effect until next year. So when I'm going through all this, you don't need to panic and think, oh my God, I need to rip up our handbooks right away. there is plenty of time to prepare for it. Yeah, move on to the next slide. Yeah, so following on from the introduction of the bill, the first stage of its journey through Parliament resulted in an amendment paper being published in November. So that amended and clarified some parts of the bill. Most of that was just really kind of technical detail, nothing too major, but I think it's just indicative of the fact that, you know, this bill is likely to evolve over the next 12 months. So you do need to keep an eye on it. You know, things will change in it. But, you know, my commentary and the rest of this talk is based on the current position after those November changes. Okay, next slide. Right, so first point to note, one of the most attention-grabbing may have the largest impact. It's removing the current requirement to have 2 years continuous employment before you can make an unfair dismissal claim. So that's now going to be possible as soon as you start work, which I think is the first time that's ever been the case. So it's definitely a big change, but there's always been the ability to make automatic unfair dismissal claims in certain circumstances, like if it's in response, well, if it's on the basis of maternity, or in response to, you know, whistleblowing or raising health and safety concerns. You know, so that's always been possible to make that from day one, and there's always been the ability to make discrimination claims without requiring any service. So as a matter of good practice, you know, we at Citation, and I'd say even our competitors, not that I'm promoting them, but we at Citation certainly would say as good practice, would recommend having fair and transparent processes for managing conduct and performance right from the start of employment. You know, you do need to, you know, demonstrate what the reason for dismissal is, so someone can't turn around and say, well, I think that was because of my age or gender or because I raised a complaint. So that good practice has really just become you know, the actual law. And the other point softening the blow quite a bit is there's still a recognition that sometimes it's apparent very early on that someone isn't going to be suitable, it's not going to work out. So probation periods, albeit labelled as initial period of employment, that'll still be applicable. That'll have less stringent rules, but you'll still need to show fair reasons and processes. Cover that a bit more detail on the next slide, Rosie. Okay, yeah, so so probation periods, it's worth noting, have never really had formal legal status. I think people kind of think it's been more of a legal thing than it has been. They've always just been a contractual tool, but they are now going to have more specific rules in law. There's going to be a lower threshold to prove the fairness of the dismissal in the probation period, and in particular, the process will be more streamlined. You know, you won't need to kind of escalate to a series of warnings like you would with someone who's got longer service. But we don't know the exact details of, you know, what those different tests are going to be. We'll have to wait and see. But also, if it is found to be unfair in the probation period, the compensation to be payable will be lower. But all of this, worth noting, will only apply if this is within the defined period, which that amendment paper did confirm will be at least 3 months, maximum of 9 months, or technically, if you give the decision before the end of that 9 months and it takes effect within another 3 months after that, you know, that's still protected as a probation dismissal. So actually quite a long period. And yeah, the reason for the dismissal has to relate to the conduct, you know, capability and performance, illegality, like if someone loses the right to work, obviously, or regulatory reasons, or what we call in the business SOSR, some other substantial reason where the contract has become kind of unworkable. But the obvious point to note that what's missing from that list is redundancy. So if you've got someone, you know, kind of new starter in a redundancy scenario, you will need to treat them the same as everyone else and not just say, okay, last in, first out. Okay, yeah, next slide. So in terms of how you can prepare for this, it's a good idea to start reviewing your recruitment and induction processes to make sure you are getting the right candidate in the first place and you're setting them up well to lessen the need for an early dismissal, which might now carry more risk. I think it's worth checking your contracts and your handbooks, and in particular the probation clauses, to make sure they're suitable for any new or stricter requirements. I think it's also wise to get into the habit of thinking through how you can justify and demonstrate the appropriateness of a termination, even if it is in the early stages, and applying more or less the same standards and processes to everyone. You know, not just sort of saying, okay, this person's only been here 4 weeks, I'll just send them a letter saying, sorry, it's not working out, and leave it at that. You are going to need to put a bit more effort in, because you will have a reason why it's not working out, why you want to dismiss them. So it's really just explaining that and kind of justifying it a bit more, getting into that habit. And yeah, finally, on retention strategy there, just getting used to having an integration and development plan for everyone, really, rather than just getting used to, you know, a constant churn being the norm. You know, do think about people, you know, longer term from the outset if you can. Yes, next slide. Right, another challenge, another change that could be a bit challenging for small businesses in particular is that SSP, statutory sick pay, that's going to become payable from the first day of absence rather than there being 3 unpaid waiting days. And the eligibility won't be dependent on earning the lower earnings limit as it is at the moment. Lower earnings limit, like right now, is £123 per week. It's going to go up to £125 in April. So that means it's open to everyone, like all employees, including those on a very low number of hours and or low wage who might have previously kind of fallen below that threshold. So everyone's entitled to SSP from the first day of absence. So yeah, I mean, people could in theory be in a position of being better paid, particularly kind of lower paid staff. They could in theory be in a position of being better paid when they're on sick leave rather than working. So for those whose weekly wage is lower than the SSP rate, which is I think about £180, they'll receive a percentage of their usual wage instead. So we don't know exactly yet what that percentage will be. May well be somewhere between 60 and 70%. I've seen kind of some reliable sources estimating about that, but we'll have to wait and see what the government announces, because the government is consulting on that appropriate proportion at the moment. Okay, next slide. So yeah, what we need to do, as it says there, sickness absence is already a major issue. It's 15% of our advice, which is second only to misconduct disciplinaries in terms of our biggest topic. And I think it's almost inevitable this is going to cost businesses more. And it may well, the level of sickness absence, the kind of frequency may well increase after these changes, because people aren't going to be in a position where they're saying, I can't afford to be off for 1 or 2 days because I'll get paid nothing at all. They won't get their usual wages, but they will be paid. So they're thinking, okay, well, I will take a day off. So absences may increase. So I think it would be helpful to put in place procedures that will hopefully help reduce the frequency of absence by keeping on top of recurring or potential issues via the return to work processes, emphasizing the need for proper self-certification in the first week, giving them support through welfare meetings and employee assistance programs and things like that, to nip in the bud any kind of recurring issues, say like, how do we kind of change things so that you don't need to be off as much, or this doesn't develop into a bigger problem. But also being attuned to potential risks, such as unfair dismissal or discrimination, particularly disability discrimination, if we are taking the approach of cracking down more on the absences, because people could say, well, all of a sudden you are threatening me with a disciplinary for being off 3 times. You never used to do that. Or, my colleague was off a lot more last year and they were never spoken to, and now you're speaking to me. So that's unfair. That's discriminatory. So you do need to bear in mind, consistency. Okay. So on to the next slide. Right. So one of the areas, excuse me. Yeah, one of the areas attracting a fair bit of news coverage when the Employment Rights Bill was announced was that 0 hours contract would supposedly be banned. That's not quite the case. You may be glad to hear. But the government is restricting them, and they're trying to prevent what they see as one-sided flexibility and potential exploitation. Not that I, at all suggest any of you are being exploitative, but this is the reasoning behind it. So there's three main changes which are listed here. I'll cover them in fuller detail in the next three slides. But there's right to a contract with guaranteed hours. There's a right to reasonable notice of shifts, and then a right to reasonable notice for any changes to those shifts, essentially. So, yeah, next slide. Right. So, firstly, right to guaranteed hours. So that the idea is to give more stability and predictability on your hours to those who want it. As I say, 0 hours contracts are not being banned. If people want to stay on them, they can. But how this will work is after the employee has worked a certain amount of hours over a certain period, they have to be offered a contract with fixed minimum hours reflecting the average over that certain period. And we don't yet know for sure what that period will be, but it is expected to be 12 weeks or there or thereabouts. And you will need to keep reoffering that. It's not just sort of you do it once after the first 12 weeks and then that's that. It does need to be regularly reoffered. And it will apply to those who are on an actual 0 hours contract, but also those with very low minimum hours, just to avoid any loophole where this can be avoided by giving someone a contract stating 1 or 2 hours a week. We don't yet know what that minimum threshold's going to be. You have to wait for the government to announce that, but yeah, it will be something quite low. So the offer also needs to be a permanent one, so not just offering them guaranteed hours for a fixed period and then reverting to 0 hours. And the offer, the change should only relate to their hours. Shouldn't be using this as an opportunity to change their duties or change their pay or anything else. It is just focusing very much on the hours point. Yeah, as I say, it's important to note that although you as an employer are obliged to offer this, the employee is free to keep refusing the offers. Because I know a lot of people say, well, my staff, they like 0 hours. It suits them. So if it suits them, if they prefer the flexibility, they want to stay on that contract, they're free to do so. But it means they also have a regular opportunity to change if they want to, or if their circumstances change. Okay, next slide. Yeah, so next point, this is in relation to having to give reasonable notice of shifts when you are, first setting the rota for the week or the month. So you need to give reasonable notice of the length of the shift and the date and time that it will start and finish. We don't know at the moment what will count as reasonable notice, but the bill has confirmed that it won't be any more than 7 days. It may well be exactly 7 days, but it won't be any more than that. So this will apply again to those who are on the 0 hours contract, or if the contract specifies certain fixed days and times, this provision, this notice will just be needed for any shifts falling outside of that. Because obviously, if it says, you are your shifts may be variable to an extent, but for a fact you will be working from 9 till 1 p.m. every Monday. Clearly, you don't need to give kind of notice of that every week. That's in the contract. So you just need to give notice of anything that's different to that. Yeah, next slide. Going the wrong direction. That's the one. Okay. Yeah, final point in this area, again on the subject of reasonable notice, is that this will also apply to giving notification of any cancellation of a shift, shortening the shift, or rearranging it, moving it to a different time. So again, the amount of notice isn't confirmed, but it won't be more than 7 days according to the bill, and that 7 days notice will be running from earlier of either when the shift was originally meant to start or when it's now going to start. So if you don't give reasonable notice, the employee will be entitled to receive compensation for that. So that's the kind of stick to incentivize employees to actually comply with this. So that compensation will be on a sliding scale depending on how short the notice was. Again, that isn't exactly defined, but we do know it won't be any more than what the employee would have earned in the cancelled shift or part thereof. So, you know, if you're shortening it, they're essentially at most going to be paid for the hours they've missed out on. If you're moving it, if you're cancelling it altogether, they are going to be paid what they would have been paid for that cancelled shift. So I think it is quite a strong incentive, you know, not to keep chopping and changing, which is the government's intention. So as well as the compensation being payable up front, the employee can obviously make a claim to the tribunal for failure to pay that compensation, and indeed for a breach of any of those rules I've just mentioned. So the amendment paper in November confirmed that the award for that will be at the tribunal's discretion, whatever they feel is fair and appropriate in the circumstances, rather than it being a fixed amount. That's that kind of final bullet point. Yeah, next slide. Right, in terms of how to get ready for these changes, first point is to just keep track of the further specific details as and when they come out. If you are a citation client, we will be updating you as and when there's any news on that, so you can adjust your procedures accordingly. Yeah, so it's worth looking at your current practices and considering how much notice you are typically giving at the moment. How often do you need to change shifts? I see someone's just kind of raised a question about that. This is the way you work. And I got to say, yeah, I know this will be a big change for lots of care clients. It will be a different way of working, but yeah, we need to sort of think ahead about how often do you need to change shifts? Do you actually need everyone to be on 0 hours or similar contracts, or could you start accommodating more regular hours in any way? Are there other types of contracts or other ways of working that, you know, that could suit the needs of the business and better in light of these changes? So you can structure your workforce and structure the pattern of work to minimize the disruption when the changes come in. But yeah, I think this will unfortunately be quite a big change for you. But as I say, we've got more than a year, hopefully, to prepare for it. So yeah, you can start planning. Okay, yeah, next slide. Right, so the deadline to submit tribunal claims, that's going to double from 3 months to 6 months. So this is something that arose from the amendment paper in November rather than the bill itself in October. It's a bit surprising because it's quite a significant change, but the significance is really just on the lawyer's side. It's of more interest to people like me, maybe. It shouldn't really affect your day-to-day work in any way, other than potentially if an issue does arise, if you think someone, you know, might be, you know, if you dismiss someone and it's a bit contentious or they have raised issues within the workplace, you are going to have a longer period of uncertainty, unfortunately, about, you know, whether they're going to bring a claim, which shouldn't affect you too much, but it's just worth being aware of. Okay, next slide. Right, so as briefly mentioned at the start, there were some new regulations on flexible working came into force last April. They gave the ability to apply for flexible working from the start of employment. Yeah, amongst a few other points, but that was the kind of key thing. That was from day one. But the Employment Rights Bill has returned to the subject, albeit it's not kind of changing anything major. There's no change to the 8 business reasons that you can rely on to refuse a request, but it will just be shifting the emphasis more onto you as an employer to explain and justify the reasons for your decision in a bit more detail. So it won't be enough to just quote one of the statutory grounds for refusal, like saying, you know, this will cause, you know, higher costs to the business, and just leave it at that. You need to explain why it's reasonable to say that, you know, those higher costs can't be accommodated and so on. Okay, next slide. Yeah, Worker Protection Act, as indicated by the title, this is separate from the Employment Rights Bill. It's an act in its own right. Quite recent, came into force in October, late October last year. It is worth being aware of anyway. But the bill then expands on what this establishes, and I'll come on to that in a minute. But yeah, the key point of this act was they created a duty on employers to take reasonable steps to prevent sexual harassment of their staff. And this was accompanied by guidance from the EHRC, Equality and Human Rights Commission, advising that not doing enough to stop sexual harassment by third parties, so non-employees, such as customers or contractors or visitors, that could also constitute a failure to take reasonable steps, and therefore be a breach. And breaching those duties can potentially lead to a 25% increase in the compensation that would already be payable if you were found liable for harassment occurring. So it's potentially quite expensive. Okay, next slide. Yeah, so how does the bill build on that? So even though the Work Protection Act is only just passed, the bill is already strengthening it. It's moving the duty from just reasonable steps to taking all reasonable steps. So you do need to go even further. So regulations may spell out what's expected in that regard, but some of the likely recommendations we'd expect are spelled out here, like carrying out a risk assessment, tightening up, publishing your plans and policies and making sure they are appropriate, making clear you've got, appropriate procedures that everyone is aware of about how they report it and how any complaints will be dealt with. That's likely to be, what's recommended in the regulations. The bill will also expand the duty to tackle third-party harassment to all types of harassment, not just sexual harassment. So it will be on the basis of race, age, sexual orientation, gender, all of that. And that will also incorporate that third-party harassment into the law itself, rather than just being kind of strongly recommended government guidance. Oh, and yet the final point, that is, disclosure about sexual harassments will be added to the existing list of what's a protected whistleblowing reason. Okay, the next slide. Yeah, so what we need to do now, steps that should be taken, all really revolve on, as I say, ensuring the systems and practices that you hopefully already have in place on harassment are properly enforced, and they're strengthened if need be. For instance, ensuring that your policy is well worded and clear, and making sure that everyone remains aware of it, so it's not just sort of given to you on your first day and then forgotten about forever. You have regular refresher training, making sure you do take appropriate action when you become aware of an actual or potential issue, just to nip it in the bud. And it's also definitely worth having a risk assessment addressing harassment specifically. I think the legislation is coming pretty close to making that almost a legal requirement. I think it's going to be one of those where if you don't have a risk assessment, which is a health and safety document, obviously, you're going to have to be able to explain why, and that will kind of be a bit of an uphill battle. Okay, next slide. Yeah, so there were some changes in the Employment Rights Bill to the existing family-friendly rights, family-related rights, but these were mostly quite small. Paternity leave and parental leave are now going to become day one rights, as the likes of maternity leave already is. That's not too radical a change, but that is just something to be aware of. Bereavement leave is currently actually only open to parents of a child under 18. It's only parental bereavement leave at the moment. I think people sometimes assume that bereavement leave is an existing legal right on its own, which it isn't, but it's going to become one. It's going to be expanded to a more general right. So it's currently for parental bereavement leave, it's for 2 weeks. It's going to be expanded to a more general right, but only for 1 week leave. Except for parental bereavement, which will remain at 2 weeks. That's probably going to just relate to close family bereavements, I would expect, but we'll have to wait for the regulations to confirm if it's any wider than that. Another quite recent change that isn't mentioned there, and it's in separate legislation to the Employment Rights Bill, is neonatal care leave and pay. That's only, the full details of that have only just been, that's coming into force in April, but the full details of that have just been published just over a week ago. So that applies to parents of children who are admitted to hospital for extended care, so at least 7 days continuously admitted to hospital within 28 days of birth. That entitles them So up to 12 weeks of additional leave, which will be paid at the same rate as statutory maternity pay. But hopefully it won't be too often that you have staff in that unfortunate position of having a newborn child admitted to hospital. But it's just worth noting that it does exist. Okay, next slide. Right, one of the more interesting changes, I suppose, from if you take an interest in these things, albeit one that might not affect your day-to-day work very much, it's the creation of the Fair Work Agency. So that's going to unify the various bodies which are currently responsible for enforcing compliance with things like the minimum wage or illegal working. I know Peter mentioned at the start about, gangmasters, modern slavery. They are very much in the remit of the Fair Work Agency. Their remit will eventually be quite wide. It's starting off relatively narrow, but modern slavery and gangmasters are in there, as is, I think, minimum wage enforcement. But it will, over time, their remit will be expanded. So as well as quite serious breaches like modern slavery and exploitation, they could address all sorts of any little cutting of corners, any kind of poor practice, like not providing proper contracts or pay slips. That could be within the remit of the Fair Work Agency. So this might result in you being inspected more often for whatever reason. It's also worth noting that this isn't replacing CQC. CQC will still be obviously dealing with the kind of standards within care, but the sort of more employment side will now be the responsibility of the Fair Work Agency. So you may be inspected by them more than you currently are, unfortunately. But part of the reasoning for the introduction of this is that it will be helpful for employers as well as employees, in that it will be clearer, who you go to for guidance, who you go to report concerns, and if any issues do arise, who will be dealing with it. So you're not saying, like, I don't know if it's going to be HSE or HMRC or the Gangmaster Licensing Authority or whoever. There will just be the one body dealing with everything. So that'll make the compliance and enforcement regime more efficient, which will hopefully, be to everyone's benefit. Okay, next slide. We're nearly there. Right, so the bill actually made quite sweeping changes to trade union legislation. This was one of the kind of biggest areas of reform, but I don't believe you are a particularly unionised sector. I mean, feel free to ask me any questions if you are very unionised, but we won't dwell too much on the relaxation of the rules on union recognition and strike ballots. But I think points 2 and 3 there could have more of an effect on all employers. Firstly, that you will have to give a statement confirming the worker's right to join a union and explaining what rights arise from being in a union. You need to give that at the outset of employment alongside their contract or particulars of employment, and it needs to be given at regular intervals thereafter, reminding them. Second key point is that unions will be able to apply for access agreements to enter the workplace, to carry out various functions, meeting staff, representing them, organising them in the sense of raising a collective grievance or, having all the same stance on something they're unhappy with. What they can't do is come into the workplace for the purpose of organising industrial action. They can't sort of be using company time to organise a strike. But this importantly applies even where the employer doesn't recognise the union. You can't kind of sit back and go, okay, that's irrelevant because we don't recognise a union. This is going to be applicable even without that. It's almost like a kind of mini recognition. But it does need to be done in a reasonable and regulated way without undue disruption to the business. And there are quite clear rules on how they apply for that access agreement and on what basis you can refuse it and that kind of thing. But, more details will come out on that in due course. Okay, next slide. Right, so that was all just a very quick run through the actual changes that are coming up. In terms of planning and preparation, the bill's still progressing through various stages in Parliament. Public Bill Committee has reported back quite recently, a couple of weeks ago. It means it's now going to its third reading in Parliament quite shortly. Government has already indicated that the vast majority of those provisions will come into effect in early 2026, which, generally speaking, these changes happen in either April or October. So I would expect April 2026 for most of those. The union changes I just mentioned a minute ago they'll probably be the middle of this year, but hopefully won't be kind of have too much effect on you. But some of the provisions, and in particular the unfair dismissal point about making that applicable from day one, that's going to be in October 2026. The government have already confirmed that's not coming in any earlier than October 2026. So yeah, plenty of time to get ready for that and everything else. Okay, that's all from me, and I'll hand back to Rosie.
Wonderful. Thank you, Dominic. So much to go through, so many things, but I think it's a really good point you make. There's still time to prepare and get ready for changes, and we don't even know absolutely everything in kind of confirmed yet. So great to kind of get a good idea, a good overview of what to expect. And I think I can't see them properly on this screen, but I think there's been a few questions or at least comments in the chat. But before we get to those, I just want to do a quick kind of run through of our solutions. So as I touched on earlier at the beginning before Dominic began, when it comes to your business, you can think of Citation as your partner for everything HR, employment law, and health and safety compliance. And we've heard from Dominic just now about all of the legislation changes due to the Employment Rights Bill. So with so many areas to navigate, it can become quite tricky, time consuming, and sometimes quite confusing just to keep on top of everything. So essentially that's where we can come in and support you if you need our help. So with our advice guarantee, which defends you against tribunals, tribunal claims, our HR and employment law and health and safety consultants, creating your contracts, your handbooks, keeping those up to date, which is really key. And of course, our 24-hour advice line where you can speak to our team of experts. Dominic and his colleagues work. So we're all on hand to support you, make sense of things, and just give you that time back to focus on running and supporting and growing your business. As well as those core HR, employment law, and health and safety services, we've also got a suite of care-specific products for you. So from mock inspections, giving you really invaluable insight into your current performance against the new framework, and we all know how frustrating things have been CQC-wise recently. So it's just really brilliant to have that kind of benchmark to get hopefully some much-needed clarity. Care-specific policies and procedure templates, to CQC Pro, which is our digital platform, helping you to manage ongoing CQC requirements. And again, to help you prepare for inspections and ensure you always know what's going on in your service at any point in time. So essentially, our range of products is designed to support you and take the stress away from compliance. By being part of the Citation family, you'll be in a really strong position when it comes to areas such as facing tribunal claims, injuries and accidents in the workplace. As you can see some stats on screen about the likelihood or the reduced likelihood of these instances occurring. And we're here to hold your hand to help you build a safer, happier and more productive workplace. Thank you for listening, and thank you for Lcas for inviting us to speak today. And if you'd like anything more on what Dominic's spoken about during this session, or to discuss your individual business needs, pop a note in the chat or send an email to seminars@citation.co.uk, or you can be really fancy and scan the QR code to give you more information. In a moment, when I'm stop sharing my screen, I'll pop my details on screen as well. So you've got various different avenues to access information and support from Citation. So thank you very much, and we'll pass over to any questions or comments that anyone may have.
Thanks for that, Rosie and Dominic. Before I actually get the questions out there, one thing I will say is that people who are signed up for Citation already actually don't know a lot of the things that are available for Citation and probably don't utilize them as much as they should do. We get lots of people who actually come to speak to Peter and I, and they say they actually have signed up for Citation. So Citation are helpful, and you can look at the range of services that they do. Speaking to Rosie or the advice line, these are some of the things that you can explore as well, and do utilize them, because you'd rather, whilst you're paying for something, make the most of it and help you in what you're doing as well. That's what I would turn around and say. But thanks for that, Rosie. Peter, I don't know if there's anything you want to raise before we go through. Dominic, hope you're ready for the Q&As that are going to be coming at you.
Yeah, I saw quite a few coming in. Yeah.
There's just a couple of things. The one thing you mentioned yet another agency coming to add joy to the general workplace, particularly in social care. let's hope they're a bit more competent than some of the ones that are there already. But we've also had issues around the Employment Agency Standards Inspectorate.
Right.
And I'm not quite sure where they lurk in the jigsaw, or whether they're going to go away or be part of something else, or...
Do you know what? I don't know 100%, but I would say with relative confidence that the Fair Work Agency is intended to replace them alongside various other people. I think in the Labour manifesto, they were saying there's over 30 agencies regulating various different aspects of employment law. And I looked at that and thought, blimey, like I couldn't list all of them. Like that was a surprise even to me. But the idea was all of those would be consolidated into one. So I would imagine that, yeah, that kind of agency worker regulator would fall within the new one. Yes.
I think that there seems to be a couple of areas that have cropped up, which perhaps link with the way that some local authorities are progressing contracts, or be they contracts or spot contracts. And that's around, say, things like the use of direct payments, where there may be, or personal assistance, where there may be self-employed people involved. That's a very difficult area to regulate. And there are social care providers who, if you like, have staff who are employed and self-employed because of linking with DPs and PAs. And that can cause lots of problems. And local authorities do seem to be pushing more towards the use of DPs because they see it as a route to cut cost. And that can bring in things like, at the moment, that can be bringing in the employment agency standards. And apparently, although it seems to vary from area to area, just to add to the general joy of the thing.
Right. Okay.
Right. Go on, Dominic.
Yeah, I mean, I'm not quite sure how that will pan out, but yeah, I think yeah, they will be looking at, to what extent are those people genuinely self-employed, and how should that interact with them being a worker or an employee in terms of doing the same work.
I think it's
yeah.
What we're seeing to a degree. Dudley may not agree with this, but because there has been shall we say, a lot of sponsored or international recruits,
yeah,
who have been treated very poorly in many cases. The way that the UKVI and the Home Office have done their triangulation is working with HMRC, and HMRC have then picked up that there may be other issues that they can pounce upon. And it actually means that we all know that the social care is made up of many, many small providers, lots of them very, very small. And I think it makes it very important for them to have some sort of outsourced advice line, so that somebody they can talk to, because you can be a very good registered manager, but your skills are not in, say, finance or health and safety.
Yeah.
And these are areas that can be very easily picked up. And, someone that's providing very good care, maybe have their business pulled apart because there's an issue on paperwork or health and safety or HR management, something like that.
Yeah, I mean, I think, yeah, you're right that it is important to then, to have it kind of integrated, that the Fair Work Agency, I think they will come in and be saying, like, yeah, so it's not like one agency is looking at one aspect and handing over to HMRC. They will look at each individual in the round about saying, okay, first of all, is this person on the right employment status? If so, are you handling their tax affairs the right way? Is their immigration status all in order? Are you giving them appropriate notice of their shifts and so on? So I think it will be, more and more important, as you say, to appreciate how it all interacts, which is very difficult to keep on top of, unfortunately, where, as you say, if you're a very small provider, you're not an expert in any aspect of these areas, but you are unfortunately going to have kind of establish the right procedures to get at least the sort of the basics right in each area. But yeah, just sort of be prepared for how they do affect one another, how treating someone as self-employed compared to a worker is going to affect their tax, and how is that going to impact on your sponsorship license? Yeah, it is. Sorry to be kind of doomy about it, but it is going to be kind of hard work, potentially more so than it is at the moment. But I think the government's position is that, well, they have said that we are pro-business and pro-worker, but I think the main on the balance, it is more to kind of protect workers' positions here, about saying that we don't want to kind of place too much burden on employers, but we are making sure that workers and employees are not being unfairly treated, whether deliberately or kind of accidentally. So yeah, I think there will be a lot more emphasis on making sure they are treated consistently and fairly in all regards.
Thanks for that, Dominic. So just to let everyone know, we're gonna go through the questions in the chat, but also as well, anyone who wants to ask any questions, please put your hand up. Now's a good time. This is, I guess, for free before anything else, but make the most of it while you can. Just one question I'm going to ask, because I think a lot of people probably like to say this. What's the CQC stance and take with these changes? Because I think most of us comply to the regulations under CQC. So I guess being compliant with them is probably the first point of call. So generally speaking, has CQC mentioned or said anything in regards to all of this?
I think that's one for Mick, if he's available.
Okay, well, Mick, you can answer that later. So just put that question in your pocket. And we're going to start, I think we had Carly who had the first question. So I'm not sure she wants to either. We can go through it, or she wants to answer it herself. It's up to her. But from here it says, does this include, and I think this was in relation to employees who are of sponsorship with someone else, as it states they can only work 20 hours with another company, and will we need to state in contracts for them 20 hours? So this is now, I'm sure you're going to get a few sponsorship questions coming in of how this covers sponsored workers. Yeah.
Okay, so I'm not trying to avoid answering anything, but our usual caveat is that immigration law on sponsorship is a different area of law. We have to be very careful about the extent of the advice we give on that, because we're not regulated for immigration law questions. But yes, so just in general though, so if you're taking on someone who's got a sponsorship, just so I understand the question, someone who's their sponsorship license is held by a different employer, but you're kind of giving them hours as a second job, is that the idea?
That's right, Dominic. Yeah.
Right, and so then you're saying, like, so if you're giving them up to 20 hours, what's your question? Sorry, in relation to that.
So would the 20 hours need to be included in the contract?
Yeah, I think you would need to spell out quite clearly in the contract, what the minimum and indeed maximum hours are. Yeah, and and making sure that you are not sort of exceeding that, and therefore placing not only yourselves in breach of the law, but them. And I suppose as the individual, they may feel like, well, I know I can't work more than 20 hours, but I feel under pressure to agree to it if that's what the employer expects. So I think it's worth just sort of keeping tabs on who that applies to, and bearing that in mind when you are setting the shift pattern, as well as all those points that I mentioned about the reasonable notice.
Okay, that's great. Thanks, Dominic.
Yeah.
Thanks for that, Dominic. I mean, there is another point here that you've raised, because I know a lot of the dom care providers are saying, how can we guarantee X amount of hours when with, contracts may not be determined by ourselves, it's determined by a local authority, some on spot contracts.
Yeah.
So then it becomes slightly trickier of putting a guaranteed sort of caveat of hours, and what is a guaranteed set of hours which is reasonable, as well as the next question.
Yeah. Well, there is no easy answer to that, unfortunately. I think this is going to be one of those where, trade bodies, representing care amongst anyone else, they will they have the opportunity to make representations to the government, and I'm sure they are, saying this isn't going to work for us. You need to either change the rules in general or create a carve out for certain sectors, explaining how this isn't going to work for you. So it may well be that as it develops, it gets sort of fine tuned to say in certain circumstances, like if it's not your decision, it's sort of imposed on you by an external customer. That there may be kind of exceptions. I don't know, but I would expect that may well be the case. But also, it will be that if this applies to everyone, local authorities or whoever are going to have to play by the same rules. Whoever they go to will be bound by the same rules, so they will have to kind of change their mindset as well and say, okay, so we're going to have to actually change the way we give instructions or tender for business from care providers, because they are stuck with the requirement to give guaranteed hours and the requirement to give reasonable notice. So they may well have to change their practices as well, so that they can actually get someone to provide that service to them. So hopefully that will take the edge off. I mean, it's a pain in the backside for the local authority as well. But yeah, it's as long as everyone's more or less in the same boat, it sort of mitigates it somewhat.
Thanks for that. Next question we had up here, it was around right of notice of change. Dom care clients make various changes all of the time. How can we be expected to sort of like give reasonable notice? I know it isn't coming in yet, but how can sort of people, what's reasonable notice, I guess, under these circumstances that we work in as well?
Yeah. So, I mean, as I say, what it's sort of setting out as reasonable notice, they've already made clear it's not going to be more than 7 days. It's not like you're going to need to give a month's notice, thankfully, but I know, in your circumstances, even 7 days might be quite a long period, saying like we may have to do it the day before. Hopefully there will be kind of exceptions, saying like, if it is just genuinely not possible, if there's an emergency or circumstances demand it is just not possible to give that degree of notice. It may be possible to give shorter, but there will be rules around how you do that and when you can do that. But it's, I suppose, just trying to anticipate, I suppose, which ones are likely to be more unpredictable, and trying to incorporate that as best you can. It's the practicalities of it. I'm not quite sure how we build into it, but I think it is just trying to plan ahead about when you're setting the roads about how confident can we be that this is definitely going to remain the case, and are we going to need to change it, and trying to avoid unnecessary changes, I suppose, wherever you can. Quite often where you've got no choice, but if there's ones where you're thinking like, you may be currently thinking like, we'll just sort of build some flexibility in to give ourselves some leeway, may have to kind of cut that out to some extent, unfortunately.
I mean, what I would say is that having a general contract which gives you under conditions which would include changes in circumstances. So for example, if someone is end of life, we know that their needs could change just like that. And obviously you can't determine how someone is in the morning to late afternoon. So things like that probably would be, something to consider, which I would think a lot of providers may think of.
Yes, certainly. And hopefully that would be the kind of thing that is recognized as an exception, because that is not so much for care, but for most businesses, you'd say that's a real kind of extreme situation if it's literally life or death. So hopefully they would recognize that in emergencies or literal like life and death situations like that, there would be kind of exceptions, hopefully. But we'll have to see how it develops over the next year.
Okay. I'm going to move to the next question. I know there's a question there on COS, but I'm going to come back to that in the end. There's a question on SSP. Employees will be eligible for SSP with a self certificate, or they need a GP sick note. So do you know what?
Yeah, that's a good point. So I think this is one of those where I think it's more about what the Employment Rights Bill doesn't say. So it doesn't say that there's going to be any change to the current rules on self-certification or when you need a fit note. So it doesn't say there's going to be any change. So I would take it from that for the first week, they still won't need to provide a GP note. If they can provide one, all the better, but they don't need to provide one for the first week, but they will still be entitled to the SSP regardless, as long as they comply with whatever notification rules you have as a business. But I don't know, calling 2 hours before the start of your shift or whatever it may be.
I think that the other worry is that, thanks to that, is that there's lots of workers, and I'm sure providers will know there are many workers who somehow turn out to be sick, just a flip of a hat, and I'm not gonna. So many people know who they are, or who they have. So I guess the worry is that, why should those individuals come to work? They're really coming there genuinely to, some even almost with their legs hanging off, almost half. And then there's others, the wind blows and they're sick. So then it almost allows, then people say, well, if that person's off sick, they can do that, then why can't we all follow them? So there's almost that side of things.
I think that is the concern. I think that is a problem, because I think, the very kind of virtuous justification of this change is to protect people who, as you say, are dragging themselves in when they really shouldn't. But I know of people currently who are working when they're not fit. They're potentially making themselves worse. If they've got an infectious disease, they're then infecting other people by coming in because they're saying, I can't afford to be off. So I think the idea of these changes is to say, like, no, take the time off, take a day or two to recover, and then it doesn't turn into a long-term sickness, and that's better overall. But yes, it is unfortunately open to people saying, like, oh, great, I won't get the full pay, but I will get paid, so I will just have that day off. So I think this is where it is important to, as I said on the slide, keep on top of them, keep challenging them about saying, well, why were you off yesterday? Don't sort of accept, oh, I was just a bit sick. So, ask the question like, well, why were you sick? You've been off sick several times in the last 3 months. Is this a pattern? Is this something we need to be worried about? If people feel are under scrutiny, it may not stop them altogether, but hopefully they will think twice about, pulling a sickie, so to speak. So yeah, holding return to work meetings, asking them to self-certify properly, saying this is becoming a pattern, we're going to have to deal with it soon because you're taking too much time off. All this kind of good practice, which maybe people have sort of been too busy to kind of keep on top of. If it's just a day here and there, hopefully that will discourage people pulling a sickie. But as long as I said before, it's not tipping over into, a kind of witch hunt against someone who is genuinely, unfortunately off sick a few times and may even have an underlying condition which counts as a disability. As long as you're not kind of taking it too far and persecuting people, which I'm sure you won't. It is just, keeping on top of things so that they don't feel that they can just sort of get away with it, that they are going to be challenged. Hopefully will help mitigate that, but unfortunately probably won't, cut it out altogether.
Okay, thank you. Next question we had here was around, can you clarify the holiday pay? I think, is it accrual? Did you
Accrual,
yeah, cool. So did you mean that we should pay accrued AL monthly and not when AL is registered?
Yeah, that's basically it. Yeah, I'm going to have to troll this out because this time a year ago I would have known this inside out because it had just come in, but like I haven't had many questions on it recently. But yes, so this came in about this time last year. It's not one where you have to now. Oh, have you still got me? Oh yeah, sorry, I just thought the screen had frozen. But yeah. So it isn't one where you will have to pay it month by month. But it's just going to be an option if you have irregular hours workers, which I'm sure many of you will do. So there's actually two separate rates, one for the accrual of the holiday itself, and then one for the holiday pay. Quite often you would think you would pay them in tandem, but in each case, it is, in simple terms, looking at how many hours they've worked or how much wages they've accrued in that pay period, whether that's a week or a month, saying, okay, for this pay period, you have earned 12.07%, which is an odd number, but there is a reason behind it, which you can get into if you really want to, but it's nerdy. But yeah, 12.07% of however many hours you've worked in this period or however much money you've earned, that's now in the pot for your holiday or for your pay. And in terms of the pay, saying, okay, come to the end of the month, we're looking at your pay slip. Here's how much you paid for the hours you've worked. Here's how much you have accrued in holiday pay, and we will pay that as a lump sum separately on top of your wages. But it just means that when you actually take the holiday, you're not being paid at the point of taking it. And in fact, that will reduce your hours and reduce your pay for the month. So it's almost kind of counterproductive. And so this is always the risk. This is why this rule wasn't allowed for a long time, because then it kind of gives people a reason to say, well, I won't take any holiday because then that will bring my wages down for the month if I'm not paid for it at the time I take it. So it is important to kind of keep on top of saying, like, you still need to take your holiday. Don't kind of burn yourself out. But yet you can say, yeah, it's a 12.07% uplift on your wages for the month, or in terms of accrual, just saying, okay, so it's the start of the holiday year. We're kind of 3 weeks into the holiday year, and you've just asked for, 2 weeks off. Well, unfortunately, you can't have that because, you've only accrued, 2 days so far. So saying, like, no, unfortunately, you can't take that time until you have built it up. So yeah, that's how the kind of accrual parts of it will work. Saying, like, you are accruing at 12.07% each week or each month, and you can only, you as an employer can say you can only take the holiday once it has been accrued. You can request this well in advance by all means, but you won't be able to kind of take it before it's accrued. Does that make sense?
Yeah, it does. Just one more thing. Does that mean that, because I don't think most staff, wasn't aware that it had changed that much. So does that mean we have to let them know and say, you have the option to get it paid every month, or you can wait until you ask for it, or just leave it as it is, and if they do ask for it, we have the option to give it
by
to
all
them?
means,
Okay.
you can leave it as it is. Like, a lot of employers did think this is great and they jumped right on it, but clearly it's quite a significant change to your contract. So it's not the kind of thing you can just sort of announce, say, guess what, everyone, your holiday rules are completely changed now, and there's nothing you can kind of do about it. It needs to be kind of agreed by consultation with the staff. But equally, like, if you're happy with things the way they are, you can leave it as it is. You're not under an obligation to inform them that this is an option. If people come to you and ask for it, I would rather be paid, a rolled up amount every month. You can bear it in mind, but you don't have to agree to that. You could, if you want, have it for certain staff, but not others. Saying, like, if someone asks for it on an individual basis, we'll give it to them, but we won't change it overall. I wouldn't recommend that because it'll make your payroll and admin a lot more complicated. But yeah, there's, whatever way you want to organize it, you can, just bearing in mind that if you are almost imposing it on the staff, then it does need to be fully consulted and agreed with them as a change of terms, and quite a significant change of their terms and conditions.
Perfect. Thank you.
Okay.
Okay, so I think that's the end of the questions in the chat. I've got some direct questions as well, but I'm opening the floor. I think we had Rama who wanted to ask a few questions. So anyone who wants to come up and ask Dominic a question, please do. We are ready. So you can put your hands up, or hopefully you come on and Peter and I will pick you out, or you can speak up.
Can I just make a quick point before we start on the questions? It's less now, but it's still something we find going around social care providers, talking to social care providers and getting information from them. We do find that some of the contracts of employment terms of and conditions, job descriptions are very poor still. So it's something that you need to address, because you can be picked up by almost anybody: local authority inspectors, quality monitoring teams, CQC. It's very easy for someone to actually pick these up. So you need to address those before you even get some of these changes in place, because they are not acceptable. And Dominic has mentioned a couple of things. We are seeing local authorities expecting contractors, which you would be, to have things like an employee assistance scheme in place, and to have strict workforce welfare policies. And they are pretty rare in social care providers. So it's something that you need to look at and cost into your business, because again, they will be asked for. And when CQC inspect, they can also ask questions of the staff, which they now do, about how well they're being looked after, etc., etc. So basic stuff that links into exactly what Dominic was saying. Okay, back to you, Dudley.
You're on mute.
I know.
Lovely.
I'm about to. I knew I was going to get. I think there was another question as well, very quickly, from Lawrence, and I'm not sure if you can answer it, but it was asked about touching on sort of how many months' notice should you give staff on cause if the fixed term contract is coming to an end. And he's asked another question there: would staff consider this harassment? So I'm not sure if you can address that, or me.
Pause. Do you mean certificate of sponsorship?
Yeah.
Yeah. So how many months' notice do you need to give? I mean, the notice rules are not any different for sponsored employees compared to anyone else. I mean, I think with sponsored employees, you always have to bear in mind that, it's even more important to treat people reasonably and fairly, and not pull the rug under them because they might say, like, okay, well, you treated me more unfairly than anyone else, and I think that's because I am not British. That's something to bear in mind. But no, the actual legal rules on notice are not any different. And on a fixed term contract, again, the notice provisions are not different to a permanent contract. It is still 1 week service for each complete year of employment. But I think it is worth, on a fixed term contract, it should be obvious enough, that when that term ends. But it's worth kind of diarising that, and in good time beforehand, reminding them, okay, thanks very much. Your contract is for a year, so you will be entitled to 1 week's notice. So just really making sure that you are putting the notice in place in good time, at least a week in advance. Or if obviously they're on a kind of longer contract, it could be 2 weeks. So just really standard notice provisions. And whether it be considered harassment, well, I think people consider all kinds of things to be harassment, but it doesn't necessarily mean they are. I think, I'm not entirely sure what you think would be harassment in this situation, but kind of, I don't know, sort of reasonably staying on top of notice and reminding them that your contract is due to come to an end, unfortunately, and for whatever business reasons, we won't be renewing it. And you need to go away and think about what effect that has on your immigration status. But we are within our rights to say that, our sponsorship license and or the contract only lasted for a year, and we have perfectly good, valid business reasons why we won't be renewing that, and explaining that to someone. As long as you do that, that's not going to be kind of unfair dismissal. It's not going to be discrimination. It's not going to be harassment. Harassment is, if we get very legalistic about it, it's creating a hostile, intimidating, degrading atmosphere. Quite often, but not always, it's a kind of pattern of behavior. So I wouldn't worry too much about, just sort of reminding them, well, sort of telling them, unfortunately, we're not going to be renewing your contract. It's unlikely to be seen as creating a kind of hostile, degrading atmosphere for them in the workplace. What might be more of a concern is unfair dismissal, and saying, if I had been a British worker on a fixed term contract, I think you would have renewed it. You treated me differently and more harshly, so that's race discrimination. That's a concern. But as I say, if you're kind of transparent and explain your reasoning and demonstrate the business reasons why, then unfortunately we can't stop people making a claim or saying it's race discrimination, but hopefully you should be able to, defend that quite comfortably if you have kind of had good process and got your paperwork in order and acted reasonably throughout. Yeah.
Thanks for that, Dominic. Just talking on the element and the point you made about harassment and sexual harassment, we know that two things. When is that coming in place so that providers are aware of that?
That's already in place since late October.
Yeah, so I want providers to understand that. And what things could you have in place now? Because you mentioned about anyone coming into your environment, place of work, third parties. So what things would you suggest providers have in place and regarding this now then?
Yeah, I mean, third party harassment is the harder one to handle because obviously they are outside your control. I mean, suppose starting with your own staff, it is the obvious good factors, things like I say, like having a good policy, making sure everyone's aware of the policy and how they raise a complaint, like who they should go to, and if they feel a line manager is the one harassing them, who do they go to instead? Having regular training, which is of a good standard, having good processes, and dealing with any complaints appropriately. It's not kind of reinventing the wheel as such. It is just kind of common sense, good practice. Will be reasonable steps for your own staff, albeit, as I say, the Employment Rights Bill will make that all reasonable steps, so you might have to go a bit further to make sure that you're doing everything you can. In terms of third party, it's kind of a bit more difficult, but it is things like having notices up that you often see in various places, and like abuse or inappropriate comments towards our staff will not be tolerated. It will be taken very seriously. It is, if it is a delivery driver or a contractor or someone that is coming in via a business relationship, going straight to their employer and saying, your employee did this and it's unacceptable. You need to deal with it. Or they're not going to be allowed on premises again, or you could just say straight away, like they've harassed my employee. I don't want to see them ever again. Send someone else. That's okay. But it's but yeah, saying like you need to do something about this, or you can go to the kind of extreme option about saying like we may have to end our relationship, our business relationship with you if you don't deal with this. But it is, sort of being seen to take that seriously and reassure the staff, like, if you're being made to feel uncomfortable by a contractor, we will go straight to them employer and we'll take it very seriously. We will offer you support, or I suppose that's not kind of stopping the harassment itself. If it's a visitor, I think a lot of this, it does have to, if you can do preemptive steps, that's great, but a lot of it does inevitably have to be quite reactive, of almost a problem has to arise in the first place, or the hints of a problem. I think it's being alert to a potential problem developing about, if someone comes to you and says, one of the residents, her son comes in, and every time he comes in, he makes a comment about my appearance, or he, I don't know, touches my arm or something, saying like, rather than sort of sitting back and saying, well, no, we can't kind of challenge customers, we can't challenge family members, actually politely going to them and taking them to one side and saying, look, maybe reassuring them and saying like, I'm sure maybe you didn't realize, maybe you were just trying to be friendly, but this is how it made our staff feel. So can you please be more mindful in future? And if and if they do continue with that, you may have to get, I know, a bit stricter. I'm not quite sure how far you can go in excluding family members from visiting, but it could be, I don't know, maybe putting something in place about saying like, obviously they can still come and visit their relative, but maybe making sure they're not left alone with a kind of member of staff, that kind of thing is helpful. If you're aware of a potential problem, saying like, okay, if we know who the problem is with, making sure they're not left alone with a member of staff, that kind of thing is a good idea.
Yeah, thanks for that. I think what I had is a lot of panic from providers who said as soon as this come out, we're going to have something at the front of the building care homes that anyone who comes in signs it, says when you're on the premises, you head here to the latest rules and regulations and sign here. So if anything does happen, obviously they've been made aware. So I think there's been a whole panic to comply, just like, and it's not just the care sector. So for anyone who's listening to this, this is for any type of organization or business in the UK, and I think these rules are applying. It's just letting people know, just because we're from the care sector, even though we adhere to lots of rules, this is also an additional rule that people should understand as well.
Yeah.
Right, we're open for questions if anyone wants to have any
Can
other
I
questions.
please ask a few
Please, Rami.
questions, if that's
Yes,
okay?
please.
Hi, I have a few questions about the hours guaranteed, because the council doesn't guarantee us hours, because we could bid for clients and we may not get it. And then even if we do have clients, those clients they can go into hospital that same day, so we don't get paid. If the client's in a hospital, we don't get paid, so those hours are gone from that carer. So when you said about the notice of giving carers notice about their rota change, so that would mean if clients gone into hospital, a few clients, sometimes it could be like 3 or 4 of their clients have gone into hospital, we don't get paid for those hours and they don't get paid. So how are we meant to guarantee hours, and how are we meant to give notice, even though we get notice on that same day even?
I don't know how you guarantee that, unfortunately. I think it was a bit like, as I said before, that hopefully, like the detail we have about the employment rights bill at the moment doesn't really spell out how it's going to apply in each case and situations like that, that it is quite just an overview at the moment. So hopefully over time it will, it will be kind of fine-tuned. More details will come out about what applies in different circumstances, and what happens if you, for legitimate reasons like that are outside your control. And I think that will be a key thing, that it is outside the employer's control. They can't offer a guarantee, or they can't give the appropriate notice. How do we deal with that? Hopefully I think the government will provide more detail on that. It's just that, I suppose, waiting to see the level of detail. And as I said, there will also be the fact that this is going to apply to everyone. So I know local authorities are in a tight spot as well, but they will have to deal with the fact that, whoever they are contracting with to provide this work, they're all going to be bound by the need to give guaranteed hours and need to give reasonable notice. So I think local authorities will have to change their practices as well, which is not going to kind of cut out the fact that, as you say, sometimes things change very last minute and the local authority has to cancel it. But I think they will have to also, along with you, think about how do we avoid that as much as possible, because it's going to have knock-on effect. And maybe kind of going beyond my remit here, but speculating and saying, like, it may be that care providers, certainly bigger ones with more bargaining position, I don't know if that applies to any of you, unfortunately, but they may be able to build into their contracts with local authorities about saying, like, well, if this happens, and we are duty bound to provide compensation to our staff, either, at the moment, as you say, you don't get paid at all. It may be that we have to build something into the agreement saying, like, in certain circumstances, you will need to pay us at least a proportion of what's been lost out on, because we're then going to incur legal liabilities and costs as a result of that. So you need to kind of bear some of the cost as well. That may be possible.
Pete,
yeah.
Pete, sorry, John. Pete, do you want to come in before I just do a quick little?
Yeah, what I was going to say is we've been talking to one or two of the local authority commissioning type people to find out what their view on this is, and they do love wriggling out of a situation and saying, oh, it doesn't apply to us. Now, what a couple have said is, well, we will give contractor A, we'll guarantee that whatever it's 1,000 hours a week, and how they then spread that is their problem, not ours. So they think that will tick the boxes as far as the law is concerned.
Okay.
Now, what that may well do is make life more difficult for smaller providers, because it will be easier for local authorities to just, if they've got whatever it is, 20,000 hours a week, they'll just chop it into 4 or 5 people, because it'll go bing, 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 easy peasy. When we've been talking with CQC, which we do regularly, we have asked them about their inspections of local authorities, and they are looking more at the commissioning of health, social care services from local authorities to make a better working environment for providers. And it's a bit like turning the Torrey Canyon round, really. It's a very slow process, but the various parties are talking, but as you've said, until it's actually described in law, no one exactly knows where they're going to go. But it may well make it easier for local authorities to just use larger providers, and there may therefore be disbenefits and disadvantages to the smaller providers.
Right.
Thank you very much, Dominic. I mean, I know we're pressed for time, and thanks for actually coming in and actually showcasing what the sort of the changes are coming up and what's there now and so forth. So, so from that point of view, thank you for that. If any questions, we'll send it through to you. And I think from now we're going to have Mick coming in, who's going to probably.
Yeah, sorry, Dad. I'm just going to be
CQC.
really quick because I know that everyone needs to get, needs to go.
Yeah.
I think we're a bit.
I do need to jump off because I'm being chased out of the room. You may just see me
No-
managing
no
expectations. Right, so
problem,
thanks for that.
Thanks, Dominic.
Okay,
Thanks,
bye-bye.
Dom. I mean, I'll make it quick. I mean, I think, we're all aware in terms of the issue, there are bigger issues and something. I don't want to dismiss kind of like all these HR changes. Yeah, and they are important. I think the issue, there are bigger issues such as like the national insurance contribution increase, the national living wage increase, and potentially sort of later in the year, fair pay agreement stuff. But and I'm going to be controversial, and then I'll just light the fuse and then I'll just go. I mean, Peter mentioned, personal assistants. I mean, absolute nightmare. Self-employed, like care workers that are not regulated by the CQC. Who knows what they're doing? It's all nice in terms of direct payment because it means people could just pay whoever they want to do whatever they want. But are they providing the service and the actual? Have they got competent people like you guys have? But I'm just throwing that out there because I think it's ridiculous to be looking at, let's get rid of the 3 waiting days for SSP, which I think, is going to promote duvet days, because anyone who potentially kind of like said, oh, well, I'm not going to get paid for 3 days, so I can't, do you know what I mean? It's suddenly going to, that's going to increase. And the sector, which is already an absolute nightmare in terms of sickness, but we'll leave that sitting there. National insurance contribution increase, national living wage, sickness, whatever. Personal assistance on the increase because, of course, not regulated, self-employed. Some of them are self-employed and then got a job as well, which is even better because they can obviously talk to colleagues and say how great it is that they're kind of like paid cash in hand and are they actually doing their. But anyway, we'll leave that to one side. Going back to what Dom's spoken about, I think all of you, and I take on board what Pete said, contracts, all that sort of stuff in terms of local authority, really important. Answering Dudley's question about HR and CQC. The CQC have never really done HR. I didn't know, I probably knew a lot more than most, but inspectors don't know about HR. They don't know that much about health and safety. I mean, I do remember actually as an inspector, when I first started, there was like a book that said that we needed to look at providers' 30 years accounts. I mean, I wouldn't know one end of set of accounts to another. So some of this stuff is a bit ridiculous. And I think what we need to do, and it's being aware that these changes are coming, but all of you have got the reality of what this is. All this stuff like notice of change, I mean, let's put it in perspective, because I think what you need to think about is about common sense. If I run a dom care and Rosie's gone off sick, and suddenly I want Dudley to go and see one of my clients, if I turn around and say to anyone that, oh dear, I can't ask Dudley to go because of the notice of change, I haven't given him enough time, and this poor client has not had their medication or any food and has ended up in hospital, seriously, you need to weigh these things up. That is my view on it. Oh, it's lovely. Oh, you need to give notice. What was the other thing that kind of like, you know, comes out? Guaranteed hours. Oh my word. Wouldn't it be great if you knew, if everyone had guaranteed hours? A lot of this stuff is nice. It's a nice thing. Or wouldn't it be nice if we all had guaranteed? Wouldn't it be nice if I made sure Pete wasn't told, you know, wasn't given loads of notice that he needs to get over to Edgware and do another client visit? Do you know what I mean? In a perfect world, brilliant. But the reality is, if you don't end up, if common sense and reality is left out of this, you end up with a situation where you're saying, oh, well, you know, the law changes are saying that we need to give people notice. Well, that's rubbish in reality in terms of what you need to do. So I think you need to balance that out, because some of this stuff is not, do something about personal assistance, self-employment, and who's regulating them. Not kind of, you know, oh, what does the contract look like? Oh, have you made sure Rosie had 7 days notice about you doing a half-hour visit on a, forget it. Do you know what I mean? So there needs to be a level of practicality. I'm not dismissing it. I'm just saying you just need to think about that. My last little point is about HR and CQC, which was what Dudley asked me originally. I do take on Pete's point. The CQC will, without a doubt, be on top of stuff like culture. They'll be on top of recruitment. So if you're not recruiting, and particularly stuff like overseas or whatever, they'll be all over that, because that will be the level of where they will know and understand HR. They will also be on top of equality stuff. And being an ex kind of equality and diversity person, oh yes, great, look, you know, sexual harassment stuff's come out, and oh, and, you know, quick, let's all dance around. All of the protected characteristics are important, not just sexual harassment. So it doesn't really matter who it is. If some trader or, you know, contractor comes in and is either, you know, racist, homophobic, whether it's sexual, whatever kind of, you know, inappropriate stuff, it needs to be sorted out. And going back to, you know, what Dom was talking about, what you can do if you've got visitors that are, you know, always racist, homophobic, etc., sexist or whatever, of course you've got a right to say, if you've got a care home, you're not coming here anymore, because it's your care home. You don't have to put up with that. You don't need to do it. So in terms of answering the question, our CQC inspector is going to be looking really closely at sort of contracts, and have you given people notice about, you know, whatever, what they're interested in at the moment, really, because CQC are in such a mess, it is just unbelievable. They don't even know what day it is. I mean, just to give you some idea about the level of sort of issues with CQC, I emailed them yesterday because I looked at a report that was online where they'd actually scored a provider. So in SAFE, as you know, there are 8 quality statements. They'd actually scored 3 for each of the 8 quality statements, which 3 8 is 24. Out of, there are 8, and if you score the top, which is 4 points, that would be 32. 24 divided by 32 times 100, 75%. If they score 75%, that should be a good rating. They've given them requires improvement. I don't even understand. So I've actually emailed them to say, can you please explain to me why 75% in terms of what you've scored them gives them requires improvement? I mean, I don't suppose they probably even know what the answer is to that. All that I would say going forward, and we'll talk about this probably when I'd have a session, is make sure in terms of what Peter's mentioned about stuff like contracts, as far as you can, are kind of as good as they can be. But some of this stuff, I think, in terms of, you know, giving notice and guaranteed hours or whatever, are lovely, but it's not been thought out well enough, and particularly around sort of the care sector, where ultimately it's about providing care, safe care, and making sure people are safe. And the thing at the moment with CQC is that although they're not experts in HR, their safety aspect will be about recruitment. and it will be about making sure staff are trained, and it will be making sure staff welfare. So anything, and I think Rosie's put it in the chat about employee assistance programs and whatever, making sure you're looking after your staff. Those things are important. It won't be important, and they won't have the ability, CQC, to say, can I have a look at this contract? And oh, it looks like you didn't give Rosie sufficient notice for her to go and do an important visit. Otherwise, it'd be a missed visit, because they'd be interested in a missed visit. They won't be interested in, oh dear, you didn't give them the right amount of quality. Do you know what I mean? So I think you have to be realistic and common sense. That's all I'm going to say, really, unless you've got any burning questions.
I think you've got a fan club, Mick.
Have I? Whoops.
No, I think this is where, and it came down to international recruitment as well, where a lot of the similarities came about, where they've said that, you know, international recruits can work here, the next minute they can't work here. If the license is revoked, then they can only do 20 hours, but then they can't, there's no recourse to public funds. So what do you want them to do then? To sit on their hands and knees? So there has to be some common sense, and Home Office haven't got any common sense in regards to sort of social care. So you would expect that though employers or employer rights or people behind this who is actually administering would understand that social care works slightly differently.
Yeah, and we all know that they don't, do they? So they don't really understand the sector very well. They're not putting the money together for that, you know, for the sector really. And I think one of the difficulties, if you know, even if you take away national insurance contribution increase and national living wage increase, to suddenly say, right, there's all these HR changes as well, you know, it's just, unfortunately, it's just not really very helpful. All that I would say is that think about your services in terms of safety, in terms of what you're doing. So, and I know it's an extreme thing, but for me, you missing a visit if you're a dom care, or if you're not providing the care you should do to someone in a care home, is a lot more important, and something that needs to be looked at, rather than, oh, how much notice did you give to Rosie because she had to rush out and go and see someone, or oh, look, it doesn't look, you've had a period where this person hasn't had guaranteed hours. I mean, it's just the sector, isn't it? That's kind of like, what, you know, and you know, Dominic's right, local authorities are going to have to try and deal with this as well. But someone at some point will need to, and you guys in terms of care associations, you know, will be probably, you know, blowing the trumpet in terms of, this is ridiculous. Some of this stuff is becoming, you know, the paperwork becomes bigger and the actual reality than what it is. Can you imagine a situation where if you took some of these HR changes to heart, that you literally said, oh, I can't send Dudley out on this, you know, to this client because I haven't given him enough notice. I mean, what is the coroner going to say if that person dies as a result? Oh yeah, well, they were following HR practice. Were they? Really? So I think, and to say, I'm not dismissing it, and sometimes I just get annoyed at the, you know, the paperworky side of stuff and the law changes. But I think for me, it's being aware of it. I think it's being aware of your own issues. I think Pete mentioned earlier about if you've got contracts that are not particularly good, or they're missing, or they're whatever, someone may at some point probably look at them. It's unlikely to be the CQC, but if the CQC are, as we know, also going to be inspecting local authorities in terms of commissioning, there is likely to be what the contracts actually sort of look like. So if they're all a little bit shoddy, they may be involved. But I don't think there's going to be, at the moment, I don't think there's going to be training for CQC inspectors on, you know, these new law changes in terms of HR. So because I think they're too busy trying to actually decide what they're doing in terms of inspection, and whether they're getting rid of scores or whether they're not getting rid of scores, and what on earth they're doing. And anyway, I'm going to shut up.
Thanks for that, Mick.
For those few kind words. The problem with common sense, he says, is that you can't get a degree in common sense, so no one's interested in it. And it also comes back to us sometimes about international recruits who have come in, who have worked, slogged away somewhere else before they come in here. And people say, oh, it's remarkable to have these young people who've got some common sense. Well, I rest my case, my lord.
No, look, thanks for that, Mick. And I think thanks for bringing something around to why we started. I think the other side of it, though, everyone, is that You also have to realize as well, as much as Mick, Peter, or I like to raise and try and stand in your corner, you have the job's worth individuals who will come in. So also make sure you're compliant. So whether it's via Citation, once again, a plug there, but or anyone else, is making sure you have your policies, procedures in place, making sure that your staff know, you know, when you're doing your induction trainings, you actually give them at least aware knowledge of certain things that are happening, so that they don't fall foul of anything like that as well. So that's one thing I would advise that you do, rather than thinking, you know, because we said something. No, make common sense, but have things in writing. If, you know, the adage is, if it's not written down, it doesn't exist. But obviously having things which your staff can read in, and don't make it, for example, where it's 6 pages just for one thing. You know, put it into bite-sized chunks where they'll be able to understand and get to know what the main points are and their requirements are when coming and working in your place and establishment, whatever speciality you're working in or around as well. So that's what I would add on top of everything, of making more common sense of it as well. Peter?
The last thing I would say to you is LDSS funding for social care training is available. Use it. There is, I think, a slow take up at the moment. I've put a contact in the chat. If you want some help with that, get onto the training company. They will help you to do it. If there's only £15 million available, if that £15 million isn't used up, then the DH will say, okay, it's not needed, and they'll take it away. So either use it or lose it. It's not a difficult portal to master, and you can get some help, and there's some really good training available that will cover. So the training in effect to you will be free. So do use that training. And thank you very much, all of you, for coming. Thank you, Rosie. Thank you, Mick.
A few points before you go, Peter, before you round up. Just on culture and organizations, we recently did an event around organizational culture within your companies. A big factor is actually getting the culture of the organization in place. That then helps eliminate or to eradicate more of the things around discrimination, awareness of staff, cultures, actually cohesion, retention, better retention. So there is a piece there of actually how do you keep your good workers there by having a good culture and organization, which helps. So do bear that in mind. All these things that obviously we've looked at the employment bill is to obviously help the employee, but also as well as an employer, you can be proactive. People tend to stay in companies if they're having, if it's a good culture, there's various benefits. So all those things are there already and they counteract it. So do bear that in mind. Just going forward, Peter, we've got a few events coming up. So to make people aware, we are still continually doing our international recruitment that we've been working with some ICSs across London. And we've got a live event taking place on the 25th of February next month. We'll be sending out information for that. That'll be taking place near Tower Bridge. We've also got a few meetings come up as well. One in regards to, we'll be setting out a link. And we'll also be doing one around inspections for COS UKVI coming in, actually inspecting your premises and building for those people who've never experienced it before. For those who have a license, we'll be doing a live session of what it looks like from when they knock on your door, the questions they'll be asking as well. They're also on the WhatsApp group and also via email, we'll be sending you updates with some of the sort of things that are taking place. The care sector at the moment are trying to raise their sort of awareness around the NIC, sort of the national insurance contributions and what's going to be taking place. Please do have your say where it's possible. We'll be sending out surveys, reports, and things that are happening as well. Other than that, I'd say thank you. Peter, anything else you want to finalize and end off with?
No, I would just say that the recordings of all the meetings, including the sponsored recruitment ones, either are or will be on the website very shortly and can be downloaded from there. And just, if you've got questions, do fire them at us and we'll try and get you answers for them, and look forward to seeing you at the next meetings.
Thank you, everyone.
Bye then.
Thank you. Bye.